Welcome back to another J. Harris Academy Police Training Roll Call. I'm Joey Sperlazza. Today we're going to discuss State versus Kevin Saal about search warrants, Frank's hearings, and specifically what was included in this warrant. This is an unpublished opinion in New Jersey, decided on December 9th, 2024. However, this does affirm well-established principles that we already know. So within a search warrant, our probable cause has to be within the affidavit, within the four corners of that search warrant. If there are probable cause issues at the Frank's hearing, though the burden of proof shifts onto the defendant to show that the search warrant was not valid, it's still on us to make sure that we wrote a very well detailed affidavit that established the probable cause for whatever it is that we're searching. So there's two aspects in this case that I want to highlight. Number one was the admission of the DNA evidence and how they showed that it was valid to establish the probable cause. And number two, about the particularity. Within the Constitution, a search warrant has to describe the particular places, things, or items to be seized. If we don't have that particularity and it's overbroad, a search warrant will be invalid. So the defendant's attorney raised the affidavit's admission of a statement of statistical significance concerning the defendant's buccal swab results. The motion court failed to address his argument in its written opinion. However, during the argument before the court, the state explained that DNA testing utilized by its laboratory does not identify a perpetrator. Instead, it excludes individuals who could not be the source of the DNA. According to the prosecutor, the fact that any male relative could be potentially in the same statistical range would be explained by an expert at trial. In the responding brief, the state explained DNA analysis utilized in this case has evidentiary value at trial. The defendant's argument was misplaced. A search warrant is an investigative tool issued upon probable cause. Law enforcement was not required to demonstrate the DNA results definitely established that the defendant was the perpetrator. Rather, the totality of the circumstances, including the DNA results and defendant's usage of the car at the time frame of the murder, gave rise to probable cause. Now, with respect to the cell phone, the warrant issued pursuant to its telephonic application on August 19, 2019, after the police seized the defendant's cell phone from the vehicle pursuant to the warrant issued by the same judge earlier that day. The warrant permitted police to search the defendant's cell phone for text messages, emails, and internet searches related to the homicide or things of that nature. The defendant argued that the warrant was unconstitutionally overbroad because it lacked any limitation on the areas of the phone that could be searched or the time period that information was accessed or created. When issuing judge approved the search warrant for the defendant's phone, she was familiar with the case, having previously reviewed multiple affidavits prepared by the same detective, and found probable cause for various searches throughout the ongoing murder investigation. The detective explained to the issuing judge that law enforcement determined the phone seized by police showed up inside our tower near the location at the time of the murder, and the defendant left for an extended lunch period and came back to work wearing a different shirt. The issuing judge thus authorized a telephonic warrant to search the defendant's phone, limited to text messages, emails, and internet searches for any information pertaining to the investigation. Importantly, the court limited cell phone search to communications or searches that the defendant had around the time of the murder. The warrant was sufficiently detailed and was not overbroad. The phone seized from the car defendant drove on the date of the murder and was active at a cell phone tower within close proximity to the victim's residence around the time of the murder. The appeal was denied. Though this case is not precedential, this should be a reminder for well-established principles that we know about search warrants. For search warrants, especially in these ongoing complex investigations, some of them require multiple search warrants. If there's a new warrant, that warrant has to have the probable cause very specifically articulated within the affidavit. You can't just assume that because it was granted in a previous search warrant, we don't need to put it in this search warrant. We can't cut corners. If you do, it's likely to be suppressed. Additionally, with the particularity aspect of it, we always have to show specifically what it is that we're looking for inside of a cell phone, and that's what will justify that actual warrant. And in this case, they limited the time frame. So the more particular it is, the more likely it is to be in our favor. If you have questions about this topic, you should attend one of our upcoming search warrant classes at the J. Harris Academy of Police Training. Until next time, stay safe.